All right, good night, everyone. How's everybody doing?
Evening. Great.
Awesome
What
stuff.
up, Dwayne?
All right, I'm doing good. I'm doing good. All right. Tonight I got a
Great.
special class for y'all. So I hope you guys have your pens and paper and whatever y'all need to have tonight's class. If you miss this one, you miss this one. And so everybody got their pens and paper and drink and whatever you need. I see somebody says there. Okay, okay. All right. Welcome to all the new family members. We got some new people in the building. Tonight class is one of those class you do not want to miss. I'll say it again. Tonight's class is one of those class you don't want to miss. So let's drop some fire in the chat for all our new family members. Let's go, let's go, let's go. And I'm going to show y'all why we are the best consumer law educational family, educational community, educational forum. All right. So tonight's topic, you may be wondering, some of you may know, some of you might not. So I'm going to be doing a teaching module on what to do if you're being sued by a debt collector, right? So a lot has happened in the last few years. There was a lot of free money being given out, a lot of lines of credit extended, a whole lot of stuff happened in the marketplace. And that led to a lot of purchases, a lot of people taking stuff on credit. What does that mean now that we're 3 years later? Well, the money supply that was put inside of the economy, it, people could not maintain it, right? And it formed a bubble, a debt bubble. So, what actually happened was the PPP, stay at home money, all of that were people use them for down payments on cars, homes, luxury items, mostly cars and different things. They were interest rate drop, they were lending out, everybody was getting funded. A lot of people used a lot of credit and it was used not in the best way. There's a lot of liability spending that happened, and all of that contributed towards the debt bubble. Now, unlike banks, which are too big to fail, guess what? They're not scared to come after you, right? They're not scared to come after you. And because they're not scared to come after you, guess what's going to happen? Now that we're in 2025, a lot of people are going to start receiving summons in the mail. You're going to get sued. Debt collectors are going to buy the bad debt because it's been written off. Most of them are being written off. Creditors are dumping these toxic products. Why? Because they already collected the insurance money on it. So, for those of you that don't know, there's an insurance policy that is built inside of anything that has to do with a finance charge. So any debt that originated that has a finance charge attached to it, right? By truth in lending, an insurance policy was taken out in the event the obligor defaults. And in this case, the obligor would be the consumer. So now they have gotten their money, they have gotten those insurances. So now they're dumping toxic debt off their books. And who's going to buy it? The Midlands, LV&V, Jefferson, all of these debt collectors, they're going to buy them. And well, they just spent billions buying debt. Don't you think they want it back? How are they going to get it back? They're going to come after you, the consumer. Now, 80 to 90% of all debt collectors' attempts to collect are successful. Let me say this again. Debt collectors have an 80 to 90 success rate. So if they spent, let's say, a million, let's use little numbers. Let's say they spend a million and that 1 million supposed to buy them a portfolio of about $10 million worth of debts face value, they're going to collect anywhere from 8 to 9 million. Does everybody get what I'm saying? So if a debt collector spends $1 to acquire a contract, they're going to make $9 back, $8 to $9 back. They're going to meet consumers like us that they will have to settle out of court with or drop the case. But guys, there's over 335 million people. Not everybody has the information here. So their success rate is through the roof. What does that mean for you? Well, you better not be a part of the statistics. States have what is called a time bar debt. Some people may know it as statutes of limitation. Now, can anyone tell me what statute of limitation means? Does anyone know what statute of limitation means? What is statute of limitation? What does that mean?
The length of time that's on the debt.
Say that again, please.
The length of time they can have the debt.
So you're saying that statute of limitations mean the legal amount of time that a creditor or debt collector has to take legal action in the pursuit of a debt. Is that correct?
That is correct.
All right. Yes. 10 out of 10 answer. You are correct. The statute of limitation is debt barred by time. For example, I love using New York. New York has a 3-year statutes of limitation. So from the date of last payment or when it went delinquent, your clock starts, and 3 years from that date, they cannot sue you, they cannot attempt to collect. The debt has now been barred by time. So look what your state says. If you have a debt, if your client has a debt, if your mom, sister, uncle, somebody has a debt, go Google. What is the statute of limitations for debt in blah, 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 right? Go look up the statute of limitations for personal loans, for automobiles, for contracts, oral agreements. Go look those stuff up so you know what those timelines are. And if you're wondering why are you being sued now for a debt that's 3 or 4 years old, well, it's because it's approaching the statute of limitations. And the debt collectors know once it's barred by time, that is a useless account that they cannot collect on anymore. Is everyone following so far?
Yes.
Yes.
All right.
Yes.
Some of you might get tricked, and some of the consumers might get tricked into restarting the statute of limitations. So let me explain how that works. Remember, I said the statute of limitations starts from the date of last activity, meaning that the date it was paid last, the last payment that was made on the account. That's when the statute of limitations starts. Now, what happens if a debt collector tricks you into making a payment?
It starts over.
It starts over in some cases, in some states, not in all states. New York does not tolerate a restart of statute of limitations. Not all states participate in that crap. There are some states that knows the deceptive things that the debt collectors do, and they put laws in place to block such activities. So you now need to know, is your state one of those states that say, hey, a debt collector cannot trick or deceive a consumer into making a payment to restart the statute of limitations? Y'all need to find out if your state is one of those states that uphold those laws and let debt collectors know you cannot trick our citizens into believing that they are going to do a partial payment so you can restart the statute of limitations. No, some states does not allow that to happen. So if you get a summons in the mail, or if you are served by a process servicer or sheriff or marshal, and you get a summons, right? A statement of claim. What do you do after you receive it? Is it A, you throw it in the garbage, B, you get scared and go into a panic attack, or C, you respond? A, B, or C? Which one's the correct answer?
See,
C, you have to respond.
You have to respond. Can someone tell me why the response is absolutely necessary? Why do you have to respond?
If you don't, they'll get a default judgment.
And what does a default judgment lead to?
Means to them leading, garnishing your wages or more.
Liens, garnishments, levies on bank account, and paychecks. So are y'all seeing how the dominoes line up?
yep,
So a debt collector and debt buyers, they are banking on what? Ignorance. Why? Because ignorance pays them so much. When a consumer doesn't know, a consumer does not know. And if the consumer don't know their rights, guess what? You have no rights. So they will trick you. They will swindle you. They will be deceptive. Yes, they will. Because the average person have no clue how to respond and deal with a debt collector, much less to how to really punch a debt collector in the throat. Is there anyone here tonight that would love to learn how to really punch a debt collector in the throat? Do I have anyone like me? You off mute and let me know if there's anyone in here like me that wants to learn how to punch a debt collector in the throat. Is there anyone here?
yes,
Yeah.
yes,
I
yes.
do,
We are.
I do.
Yes, yeah.
Definitely,
I can't hear y'all. Is there anyone here that wants to
How to
learn
cut their
how to
head
punch a
off?
Absolutely.
debt
Yes,
collector
yes.
in the damn throat?
yes.
Can we
Yes.
just cut the whole
All right.
head off
Yeah,
instead
we
of
want to
punching them in
murder
the throat?
them. We just want to
Hand
murder.
it to him and hand it to him.
All right. So we're gonna start tonight's lesson. Guys, take notes. I promise you. Take notes because I have my course guideline, but there will be times when I go away from the script. And if there's things that I say, you might want to write it down. All right? Or just wait and get the recording. All right. So what to do if you're being sued by a debt collector? All right. Prepared. Let me prepared and narrated by Doreen Delamonte. Let's get it. We're gonna do this thing formal tonight, baby. All right, prepared and narrated by Coach. Here we go, Coach. We left that part out, Doreen. All right, now we're in business. Okay, so this is a consumer law connoisseur type of pre-game. This is how we pre-game in the connoisseur. So pre-game, I can give the university access to pre-game, but there's some stuff that's highlighted on here that's going to be strictly taught in the connoisseur program. All right. So the objective, by the end of this training, you're going to know one, how to force a debt validation using federal case laws, how to block collection using maximum laws, turn credit reporting into an FDCPA weapon, destroy standing using qualified accounts doctrine, countersue debt collectors for illegal collection, win dismissals, settlements, and leverage for deletion. Does this sound like something anyone on here would like to learn tonight? I mean,
Absolutely.
if that's y'all,
Absolutely.
drop the word
Yes, yes.
absolutely in the chat. Like, if this is something y'all want to learn, drop absolutely in the chat. So let's get it. So we're going to go and we're going to discuss 4 key strategies. All right. 4 key strategies, 4 core pillars. All right. So we're going to talk about the debt validation arsenal, maximum of law and risk assumption, credit reporting, collection, qualified account doctrine, and standing. So debt validation using Hinkle versus Midland, plus supporting case law. So the core legal rule here is 15 USC 1692 GB or 12 CFR 1006.34C. Once a consumer disputes a debt collector must what? Cease collection until it obtains competent evidence of the debt, right? And the primary case law we're using is Hinkle versus Midland. The key holding to Hinkle versus Midland is that a debt collector cannot rely on its own internal records or affidavits to validate a debt. It must possess admissible evidence from the original creditor. If they have internal data, that is not proof. Internal affidavits, that is not validation. Spreadsheets, no standing. Screenshots, no standing. All right. Those are those internal documents that they're using. It's not admissible. It's not stuff that you can use because anybody could generate those. We need authenticated documents, account level information, and that can only be obtained from the original creditor. Now, supporting consumer win case laws, we had Chattery versus Guller Zero. Debt validation must be independent and verifiable, not the collector's own bookkeeping. So let's talk about this one for a minute. I'm gonna repeat it, and I want you guys to tell me, respectively, of course. We're not gonna shout over anybody. What does this mean? Debt validation must be independent and verifiable, not the collector's own bookkeeping. What does that mean? Can someone tell me what does that mean?
Yes. That means that the debt collector cannot create their own documents or their own paperwork from their letterhead and send you a letter stating that you owe such things. So it has to come from the original creditor.
Ooh, who talking so spicy tonight? Who's that?
This your consumer's law. This your
That sound like
connoisseur
Sylvia.
student.
That's a 10 out of 10 answer. Yes, you are 100% correct. A debt collector cannot make robo or fake affidavits with their own internal staff and stating that the affidavit supports whatever claim they're asserting. That's a no-no. They cannot use their internal records. And this is where we talk about method and description of the procedure. Use an I6B3. Guys, when we dispute with the CRAs, right? And it comes back verified, validated, accurate. Your I6B3 request for a description of the procedure, use that information that you're supposed to receive is a part of what the reinvestigation slash validation process information should contain. The account level information and how that account level information was possessed, how they got it, where it was made, where it came from, and that type of information must be verified, right? It must have a certification of accuracy that supports the nature of what the document is saying. All right. In Fields versus Wilbur Law Firm, right? Collections must show how the balance was calculated. This is a great one. Have you or any clients have, like, I'm not going to say that that is yours, but you may have an idea. Let's say that the alleged debt being collected was $400, right? But then when the debt collector gets it, it's $700. That's strange. How did it jump from 400 to 700? Have anybody ever experienced that, whether by yourself or a client? You know that's not the right amount, but then when they are attempting to collect, there's fees and all these things added to it, with no explanation of how that was calculated. Has that ever happened to anyone?
Yep, happened to me.
All right. So I want you to write down the case law, Fields versus Wilbur Law Firm. And if we're going to use that as a core strategy in our lawsuit, Fields versus Wilbur will be a core case law we're going to use to structure your statement of claim and demand proof of calculation. Does that make sense?
Yes.
All right, great.
Yes, yes.
Haddad versus Alexander Zelmansky, Danner, and Ferrito, right? Such a long name for a law firm, but whatever. Collectors violate the FDCPA if they misrepresent the legal status of a debt. What does that mean? Let's say that a debt is barred by time. Let's use that as an example, right? If the debt is barred by time, is it collectible or uncollectible?
Uncollectible.
All right. So if it's uncollectible, if they state or insinuate or persuade or hint at the fact that they're attempting to collect on this debt, and any information used will be used in accordance to the collection of this debt, doesn't that mean that they're actively collecting on the debt?
Yep.
So if you get a Dunning letter or a phone call that the alleged debt is being collected, that is a example of a misrepresenting the legal status. The legal status of that debt is uncollectible. Yet you're having a law firm or a representative or a paralegal or someone stating that they're attempting to collect on a valid debt. That's misrepresenting the legal status of the debt. The status of the debt is uncollectible. Why? Because it is barred by time. Right? And that's what that's what makes it uncollectible. So for a debt collector to deceive and trick and use different deceptive tactics and strategies to coerce payment, that is a misrepresentation. And your Harad versus Alexander will be the best case law to punch them in the throat. So Cruz versus Midland Funding. Failure to provide chain of title equals no standing to sue. If a debt collector claims that they are now the owner of a debt, are you going to believe what was put in that statement of claim?
No.
No,
Why not? Why not?
they have no proof of the ownership purchase.
Ah. So if I say, hey, Ivy, I'm a debt collector, and Ivy, you owe me $1,000, and I'm going to sue you for it.
Go for it. Go for it.
What would you...
You have to.
Let's rewind. Let's say that I claim that I bought it from Capital One. Yeah. Capital One owned the debt. They were the original creditor. They originated the line of credit, right? And then the Rain de Levante Collection Agency is now saying, hey, Ivy, you owe me $1,000. I bought this from Capital One. I am now the legal owner of this debt. You have to pay me or I'm going to sue you. Is Ivy laughing at me? Is that what's happening?
No, that wasn't me.
Who was laughing at me? Y'all laughing at the Rain de Levante Debt Collection Agency?
Now I am.
No.
So the round one, so we're going to take this in two phases. So let's say we're directly dealing with the debt collector, right? So we're under Cruz versus Midland, right? We're directly dealing with the debt collector. What would be your round one? Remember now, we're not in court yet. The scenario is we're still dealing with the debt collector. What would be your round one in a Cruz versus Midland situation where there's a failure to provide chain of title? How would you address your round one?
Validation. Validate the debt with proof of purchase. Bill of sale.
All right. Validation. Why would we use a validation round one? Why would that be the most appropriate response to a round one claim from a debt collector? Why would that be the most best, or why would that be the best response?
That would be the best response because
No,
if they
why it would be the best response?
they cannot validate, they cannot verify, then it has to be deleted and it's uncollectible.
Very good, Ivy. A debt that cannot be validated is uncollectible. It is not valid. There is no valid claim. Therefore, there's no standing to sue. Right? So if you send out a validation notice to a debt collector and the debt collector refused to respond. They did not respond, but then they attempt to sue, and you get served, or it was on your door, or you received a statement of claim or a summons in the mail. Well, there's no standing, so your response to that would be to deny everything on that statement of claim and then put in your own
Statement of
your
counterclaim.
own verbiage, your own what's the word I want to use? You would use your
Counterclaim. Affirmative
but you
defense.
could counterclaim or countersue, but I would put in a motion to dismiss based on lack of standing, right? And the lack of standing that I'm going to ask for is based on the fact that the alleged plaintiff, or the plaintiff in this case, failed to provide not only chain of title, but the plaintiff failed to validate the alleged debt. A validation notice was sent pursuant 12 CFR 1006.34C, where a furnisher of information has 30 days to respond. LV&V did not respond in 30 days. Therefore, 15 USC 1681 I-5 stands absolute that information that cannot be verified within 30 days must be deleted. It's unverifiable. Therefore, plaintiff lacks standing, and you're requesting a motion to dismiss with prejudice for lack of standing. All right?
Yes.
I hope somebody's right. I swear to God, I hope you guys are writing this down. Right? So, teaching point. If a debt collector cannot produce the original contract, a full chain of assignment, a complete itemized accounting, if they cannot provide proof that it meets the definition of account, there's other things, right? They legally cannot collect. So, pillar 2, maxim of law, volunteer non-fit injury. What does that mean? To a willing person, no injury is done. What is the legal meaning of this? Well, if a company knowingly purchases defaulted, charge-off, or time-barred debt, right? Time-barred debt, they assume the risk. They cannot claim injury. They cannot claim damages. They cannot claim surprise. They cannot claim unjust loss. Can anyone explain to me why? Why cannot they assume the risk? Why can't they assume? Why can't they cannot claim injury? Why they cannot claim damages? Why can't they claim surprise? Why cannot they claim unjust loss? Can somebody break this down for your boy, please?
Because when they purchased it, they was knowledge of the opportunity that they would not be able to collect on the debt.
Well,
So
I
they
wouldn't
can't.
use the word opportunity. You are on the right track, but let's take the word opportunity out and let's put a different word in.
So when they bought the debt, they knew,
Mhm.
they were aware that the debt, they may not, they couldn't, they was what I
There's
want
a
to use now, I'm trying to do a
possibility.
possibility, they could not collect on the debt. So they bought the debt with that knowledge of knowing that. Now you cannot claim that you were injured when you were not injured
Mhm.
because you was knowledgeable of the debts that you were buying could be uncollectible.
Absolutely amazing. Is there anyone else that have a different point of view? But Sylvia, you are on track. Anyone else wants to give me their interpretation? All right, I'm gonna take your silence as a no, and it's okay. So legal meaning, if a company knowingly purchases defaulted, charge-off, or time-barred debts, can they say, oh, we are claiming damages, so we're going to sue Ivy? Right, Ivy? I'm gonna sue you knowing that I bought a whole pool of debt and I'm damaged now. Yeah, I'm damaged now, Ivy, so I'm gonna sue you. All Ivy got to do is build her response and defense around a volunteer non-fit injury. To a willing person, no injury is done. You knowingly, without coercement, went and bought pools of bad debt. How can you claim injury knowing that you bought pools of defaulted debt and now you are going to claim injury? How did you get injured, sir, debt collector? Right? So it's knowing these maxims, knowing really how to navigate your defenses. This is what's going to set you guys apart from everybody else. So supporting case law framework, we have Kimber versus Federal Financial Corp. Purchasing time-barred debt and suing on it is deceptive and unlawful. Mikey, you might want to write this one down. Kimber versus Federal Financial Corp.
Yep, got it, man.
Purchasing time-barred debt and suing on it is deceptive and unlawful. McCullough versus Johnson, right? Debt buyers who sue on unenforceable debts act willfully under the FDCPA, right?
Yeah, she not suing, she collecting.
She's attempting to collect it. So before it gets to the sue stage, you can cut it down unless you want all the smokes to really drag her ass through court. Unless you want that type of smoke, but you can shut her down with those two case laws.
So Durian, I sent her a refusal to pay, right? She said she's gonna report it to the credit reporting agencies that I refuse to
That's
pay.
a threat. That
Okay.
is a
But
threat,
you
and
can't.
I would use that as a part of my arsenal. I would literally start a lawsuit against that debt collector if it was me.
Yeah, I'm setting up everything, man. I got it.
All right, good. So courtroom teaching line, right? So they bought this debt knowing it was defective under volunteer non-fit injury. One who voluntarily assumes risk cannot later claim injury. And this is how you punch this line right here, punched a debt collector in the throat. Yep, that line just punched a debt collector right in the damn throat. Let's go. They're getting punched everywhere. All right. So credit reporting is a form of collection. What case law supports that? Johnson versus LV&V. Right? Regulation F, 12 CFR 1006.30. Primary case law weapon, Johnson versus LV&V funding. The court held that reporting a debt to a CRA is a form of collection activity under the FDCPA. Federal regulation weapon, 12 CFR 1006.30A, a debt collector may not collect, attempt to collect, or report a debt that is barred by time, a debt that lacks legal enforceability. 12 CFR 1006.30B, collectors must disclose when a debt is time barred before any collection. So if a debt has been barred by time, if a debt collector is attempting to collect, Mikey, they also have to let you know that the debt that they're attempting to collect on is
Time bar.
barred by time.
Mm-hmm.
And if they don't, it's a whole violation of federal laws, and it gives you another angle that you can sue on. Right? So additional consumer win case laws, Pantoja versus Portfolio, threatening or implying lawsuits on time-barred debt. Well, really, doesn't this sound exactly like what you need, Mikey? I
Yes, sir.
thought somebody threatened to put something on the credit report that is barred by time.
Yep, that's a good one right there. Yep.
That is quite interesting. Right? So in McMahon or McMahon, whatever that is, versus LV&V, collection letters on time-barred debt without disclosures violates the FDCPA. Teaching notes. If reporting is, hold on, guys, I'm getting a little bit of feedback. Just be a little mindful with your mics. If reporting is collection and the debt is time barred, then the act of reporting itself is an illegal collection attempt. Oh my God. All right, let's revisit this argument. If reporting is collection, which we saw under what? What supports reporting is collection? What case law?
Johnson
Come on,
versus
guys, drop it in the
LVNV.
chat. Which one?
What was the question? Go again.
What case law supports reporting is a form of collection?
Johnson versus LVNV.
Johnson versus LV&V. So if Johnson versus LV&V is true, which it is, and it states that the reporting of a negative item by a collection to a CRA is a form of collection, then if they are reporting a time-barred debt barred by time, then the act of reporting itself is an illegal attempt to collect. How
Yep.
are you going to collect on a debt barred by time when we have Supreme Case Court that shows that the reporting of the negative item is a form of collection? Does
Nancy
that
versus
make the
Bank of
collection
America.
illegal?
Yep.
Oh, you guys are learning some stuff tonight. If this is good, y'all better drop some fire in the chat, God damn it. All right. So, pillar 5, right? The qualified account doctrine. What is this? Now, in Bursa versus Northland, right? We saw where the key holding was that a collector must prove the account meets the legal definition of a collectible debt, not merely that it exists in a database, right? So I'm going to change this from collectible debt to definition of a qualified account. Qualified account, right? And not merely exist in a database or on a credit report or on a credit report. What does this mean? This simply means that if a debt collector is going to attempt to collect on a debt, does a debt equal an account?
No.
A debt, the debt does not mean it is an account, right? So therefore, debt do y'all know how to do the slash to the equal sign? How do you do that? If you have the equal sign and you want to get the slash through it, not equal, how do you do it? You know,
What?
nobody can help your boy out. How do you do the
What
not
are you
equal
talking?
sign? I'm
It's
looking
not
for the not
it's not
equal sign,
equal
but
to.
you know, huh?
That's what you're trying to
What do
get.
you
Not
mean?
equal to.
All right, so you know you have the equal sign
Yeah.
like this,
And
but
then you
there's
put
one that has a slash going
slash
through
to it.
that.
That
That's
means
the
it's
one I
not
want to
equal
find.
to. Yep. I don't know how to do that.
Hold
No,
on. I
no.
think
My
there was a
God.
not
There's
equal
one up at the
sign.
top.
You
Yep.
Yeah, there. I
you
think
just
there was one up at the
you're
top.
just making up stuff, Doreen.
No, look, see, it's a real
No, right
thing.
here.
Look,
Yeah.
it's a real
That's
thing.
that's not equal to, right, Doreen?
Yeah,
Ah,
It's not equal to.
it's a real
God.
thing. I just don't know how to do it. All right. All right, where were we now? All right, boom.
There you go.
All right, debt does not equal account. Right? So a debt does not automatically make it an account. ACCOU. Right? It does not make it an account. And these are the things that we need to know. Guys, we're not saying that we don't have a collection. I don't care. I don't. Nobody cares if you have a collection. Nobody does. What I care about is, are they compliant? If the collections is on your credit, does it meet the definition of a qualified account? Is it a deposit account or deposit savings? Did it meet that legal definition under the Electronic Funds Transfer Act? Did it meet it under the FCRA? If the answer to that question is no, that debt should not be on your credit. Period. Whew. This class is so good. I'm gonna have to buy it again, my whole self. All right.
Good news is
Additional standing, right? Killer case law. So portfolio versus king. Debt buyers must authenticate every assignment in the chain of title. Can someone explain what that means for me? What does it mean to authenticate?
I'm all the way to the top.
Prove.
Yes, but how? It needs to be signed, stamped.
It's certified, notarized.
Certified, notarized. Those are different forms of authentication. So every assignment, so if it was sold to 5 different debt buyers, it must be authenticated each time. If there's a time that it was bought and it was not authenticated, that document does not have any intrinsic value, or it does not have that level of credibility to say that it's a valid assignment. The chain of title was broken or unaccounted for. Midland Funding versus Brent. Failure to provide ownership defeats standing. That's beautiful.
Wow.
Right? Teaching point. If the account doesn't meet the legal definition of a qualified account, the court lacks jurisdiction to enforce it. They can't enforce what does not meet the jurisdiction for the matter that we're at. Make sense? The same way, if due process states that you're supposed to be served and you get 30 days or 14 days to respond before the court could put in a default judgment against you. But let's say that you weren't properly served, or you weren't served at all, or they send it to a wrong address. The court would lack jurisdiction over you. Therefore, the default judgment that was granted is a fake, well, not fake, but it lacks jurisdiction. Therefore, that default judgment does not carry any weight. And that is why when you put in a motion to dismiss default judgment based on what? Faulty process servicing, or let's say that there was faulty document preparation or submission or whatever it is that should have been done in the process that was not done. If the compliance was not done, the judgment becomes invalid. Y'all following? So if they fail to provide ownership, they can't sue, because without ownership they don't have standing, and without standing you can put in a motion to dismiss for lack of standing. That one was so good. Teaching point. If the account doesn't meet the legal definition of a qualified account, the court lacks jurisdiction to enforce it. Can't enforce what you don't have jurisdiction for. Right? So this part highlighted here, we're gonna do this in the connoisseur tomorrow. So students in the connoisseur, I want you to write this down for me. 1, how to answer to a complaint. 2, affirmative defenses. 3, debt validation demand. 4, motion to dismiss lack of standing. 1, 2, 3, 4, 5, FDCPA counterclaim, FCRA counterclaim, right? The core affirmative defenses that was taught tonight, we talked about lack of standing, failure of consideration, lack of privity, statute of limitations, account stated not proven, FDCPA, FCRA, payment not accurately accounted, unclean hands, volunteer, non-fit injure. These are some of the affirmative defenses that we can build our whole replies on, right? So close out remarks. Tonight you learned that debt collectors cannot collect what they cannot legally prove, cannot claim injury on debt they willingly purchased defectively, cannot use credit reporting as a weapon on time-barred accounts without committing federal violations. You are no longer defendants. You are now the enforcement hand of the federal consumer law system. Homework assignment, ladies and gentlemen. Each of you must pull your report, identify one collection. Hold on one second. Identify one collection using the Hinkleverse, uses a Hinkle, a Johnson time-barred analysis, draft a validation letter, answer the complaints, FDCPA counterclaims, the whole shebang. I will be taking questions now. We'll do Q&A. Talk to me about what you learned tonight, how you can apply it, or whatever question you may have. The floor is now yours. Sylvia, your hand is up first. Talk to me. What you got?
So, Daraine, with the account situation, who has to initiate the account? Like, say if someone took you to court and they say that, would that verbiage need to be in the paperwork, or can you just initiate this is not an account?
All right, so we'll talk about in your discovery phase, right?
Yeah.
So let's say that it's past the round 1, round 2, where we can't directly dispute it anymore. So we're beyond dispute now. We're in the realm of court, counterclaims, sues, and all that. In my discovery request, I am also going to put a request or a demand for the plaintiff to prove that the debt they're attempting to collect on is a qualified account to be on my consumer report that they have in their possession to collect on. Does it meet the FCRA and the Electronic Funds Transfer Act definition of what the word account means?
Okay.
Awesome.
Okay, so I can't wait till tomorrow call because you got dropped off and we had some good stuff going on. We need you to
Yeah.
Tuesday call.
We got some making up to do for tomorrow for sure.
Okay. All right. Well, thanks.
Yep, no problem. Josh, talk to me, Josh. What you got?
What's up, Daraine?
What's going on, my brother?
I got a quick question. So I got a client that's getting sued by LVNV, right?
Mm-hmm.
But they produce the actual bill of sale.
Well, the bill of sale is not enough. We need a lot more than just the bill of sale. Have you read the ebook, How to Punch a Debt Collector in the Throat?
Nah, but I'll get on it though.
Yeah, it has your blueprint. The blueprint you need is in there.
All right, cool.
Okay, so let's say that let's say that 12 CFR 1006.34C requires a debt collector to produce 14 pieces of items, right? Hold on, let me just get something real quick. Give me 1 second.
Josh, did you read the bill of sale? Is your name on it?
No, it's for a client, but yeah, their name is on it.
Oh,
All right. So I'm back. So remind me of the question again. I've been losing my train of thought real quick.
So
if bottle of water.
If a debt collector sues you and they produce the bill of sale, like how would I address them with the court response?
Okay, very good. All right. A bill of sale does not constitute validation, right? So what we need to do as consumer law connoisseurs is we need to know what does the validation process require. So if Devin is a debt collector and I am Josh and I send out a validation notice to Devin, me, Josh, should know what things Devin is supposed to send back to me for proper validation. Now, let's say out of the list of 8 things that Devin is supposed to send back, he only sends back 1 or 2 items. Does that constitute proper validation?
No.
No.
No, it does not. Therefore, validation was done. Therefore, we have triggered a what? A Hinkle versus Midland.
Mm.
Who's following?
Yep.
It's invalid. In order for the validation to be valid, all required disclosures and documents from 12 CFR 1006.34C must be produced. There is no negotiation. It didn't say produce some. It says a debt collector shall provide the following.
So that would be my response back to the
Yes,
courts.
your following would be a screen. What did they send you back?
The bill of sale
A bill of sale
and the
does not constitute validation. Validation under 12 CFR 1006.34C requires all the information stated in that law. Whoever is reading this letter, if you are incapable of conceiving the words that I write on this piece of paper, you need to take this to your legal department so they can explain it to you. You have failed to provide validation. It has been more than 30 days. You failed, in all caps, you failed to validate the alleged debt. You are hereby required by law to delete this debt from my consumer report effective immediately. If 7 to 14 days pass and this account, don't call it an account, and this debt still is on my consumer report, prepare to see me in court. I am going to whoop that ass in court.
and they also they provided the like the assignment from, I guess, the original creditor.
Means nothing.
All right, cool.
Means not. It's like, who did anyone watch Black Panther?
Mm.
All right.
Yeah,
Could
I did.
Thanos do the reset with 1 Infinity Stone?
Nope.
No. Could he do it with 2 Infinity Stones? Nope.
Nope.
3 Infinity Stones? Nope. He needed all 6. Was it 6 or 5? I don't remember. It's one of them. But let's say it's 6 right now. All right. Let's say it's 6. Wait, 1, 2, 3, 5. Let's say it's 5, right? Let's say it's 5 Infinity Stones that was needed to do the reset. Thanos couldn't have done it with 4. So if you get 4 pieces of information back from the debt collector and the law says they're supposed to give you 5, that's not validation. You have incomplete Infinity Stones.
You know what they do? Sometimes they just give you. Sometimes they don't give you the full purchase and sale agreement. They give you a little part of it. So the part that they don't give you the. Sometimes the purchase and sale agreement is like 30 pages.
Yeah, and I'm saying it doesn't matter how much it is. If they don't give you every piece
Right.
of information required, that is an invalid attempt on a validation which they failed miserably.
Yep.
And you're going to rub that right in their face. Get this alleged debt off my credit that you can't even validate, and don't even speak to me no more. If you do, the next conversation we have will be in court.
So Darain, it's already in court. So that would be my answer with the court. That
No,
that's
your
not.
eyes. Well, we're not gonna say that if we're in court. We're not gonna say we're gonna drag that ass to court. No,
Yeah.
we're gonna modify that language now, and we're gonna do a motion to dismiss due to lack of standing, failure to provide adequate validation information person 12 CFR 1006.34C. Like, that's what our motion would be under. We'd do a motion to dismiss for lack of standing based on invalid attempt to validate the alleged debt.
All right. All right,
All
cool.
right.
Make sure you answer the summon too, because you have to appear in court within
Yeah,
40.
yeah. You have to answer the summons. So, Josh, you're in connoisseur, right?
Yeah.
Yeah, we can go over how you're gonna draft that tomorrow. That's simple, bro.
All right, cool. And I went to court with credit acceptance today,
How
so
was that?
it got moved to arbitration, and yeah, they basically got to pay the fees.
Yes.
Yeah, so they
And
they
how
sent
much
me.
was this alleged debt they're attempting to collect?
It was for the late payments. The account was paid off and settled, but they still had the 180 days late payments reporting.
All right, we're gonna take them to court for this late payment, and we're finna drag it out.
Yeah, so they gave me, they dismissed it, and it basically just says that we have to go to arbitration.
Arbitration?
Yeah. So I guess I'll ask you tomorrow, like my next step would be filing the arbitration, like initiating it, or do they do that?
Oh yeah, oh yeah. Because if you wait, so if you wait for them to do it,
They're not gonna do
they
it.
will just leave it in the air. They won't do nothing, right?
Mhm.
But then the item may still be on your credit. So if you initiate it now, you are start. So in this case, you're the plaintiff and you're initiating the arbitration, which they have to pay for. So
Mhm.
now they have to come and pay and attempt to defend this alleged payment they have on there as late with no disclosures, nothing that was provided. So the entire basis of this is late payment. We don't care if you were late. The whole basis is compliance.
Mhm.
All right.
We don't care about your late payment. Nobody cares about it. What we care about is the compliance procedures that was involved in this alleged payment being put on the report as late. So the late payment is secondary, the compliance is primary. We'll dive more into it tomorrow.
All right, yeah, cool. Yeah, because the judge pretty much told me when we was done, he like, yo, if they don't follow through with arbitration, you can come back and refile.
Countersue. We're
Yeah,
gonna
counter.
countersue them
Yep.
for yeah.
Mhm.
We'll talk about this more tomorrow.
All right, cool.
Awesome
All right,
sauce.
thanks, Lorraine.
Yeah, you got me excited for tomorrow.
All right.
Shelly.
Hey, Durain. That I sent the response in for the suit that they had against my son, and
Mm-hmm.
I sent it to your email, but you probably got a lot of stuff. Um, they sent me back an order for referral, for mediation, and I was like, "How'd you get me?"
Oh, mediation. Okay.
And then the mediation. Let me see. When is the date? Durain, the date is. What's wrong with these people? The date is in April of next year.
Golly. Ugh.
Like,
They must be backed up.
I know, right? I was like, what is really going on? April of next year, April 26th or something. April 13th of
Of 2026.
26 at
All
10:30.
right.
And of course he doesn't have to appear in person, but he has to but my thing is, if I'm asking for them to produce everything, is that something that they would have to produce in this um
You can decline the mediation, it's not something you have to accept.
oh,
Mediation is if you want a resolution before court. That's what
Settlement.
mediation is. It gives us an opportunity to say, hey, you know what, Shelly? I don't feel like going to court. I just don't want to. Can we settle this and we'll come to some agreement? That's what mediation is. It's
yeah, but I'm
basically giving you
that
the
it's
opportunity to come to an agreement.
but if we're not even agreeing that it's his debt, I asked them to produce all of that. So why did it get sent to mediation if all the stuff that I put in there?
It's an attempt to resolve it without wasting the court's time. If this can be resolved, so you're going to bring all your evidence and stuff to mediation, right? And if you make a compelling argument in mediation, and then the other side sees that, damn, we have no way of beating this person, they'll settle
Makes
right then
sense.
and there. So it never has to go to court. But let's say mediation failed and y'all just can't come to an agreement, there will be now a court date will be set after mediation.
So
It's
the
just how
burden is
the process works.
so the burden is proof is still on them. They need to be able
1,000,000%. Your job is to point out their failures
Yes.
or lack of compliance.
right. The same thing that I submitted to just point
Correct.
all of that
And
out.
and
Mediate.
it's their job to prove that what you're saying They were compliant.
Okay, I'm gonna teach my son this because he has to do it. Okay, so that's exactly
Ooh,
what
you
I
finna teach him. That's what I'm talking about. I really love the way that sounded just now.
Hey, Duran, can't you send it to Discovery?
No, not
No.
yet, Mikey, because
Mediation.
it's not in court yet. They're
Oh,
going
it's
to
in mediation.
mediation.
Oh, okay.
Yeah, they're gonna go to mediation first.
Okay, I got till April to teach him. I'll just go on and let him learn something.
Yeah, that's a lot of time. Let's get it.
Yeah, yeah. Okay, that's great. Thank
Awesome
you, Rank.
sauce.
Mhm.
All right. Devin, talk to me, D.
What's going on, Durain?
Working, my brother. What you been up to?
I'm chilling, man. So I got the attorney for representing LV Funding. He left me a voicemail pretty much saying he wants to settle. So
Oh,
yeah,
let's go.
yeah. So so I put the claim in. He contacted me through phone. I didn't answer at the time, so he left a voicemail. I called him back. He didn't answer, so I left him a voicemail, pretty much saying for documentation purposes, send me everything via mail or through email.
I
And
like that.
so he pretty much sent me an email, pretty much saying, as requested in your telephone message, we are communicating with you via email. Please let us know if you're interested in pursuing settlement discussions. My
Oh,
client is willing to submit a trade line deletion, a debt forgiveness, along with one-time $500 payment to you. In exchange, we will require to discontinue the action you filed with prejudice. So I put a response in ChatGPT because I wanted to get more out of it besides 500. So I just wanted to know if this language sounded correct before I email him back.
That's
I said,
500. That's a penny.
yeah. So the max I could sue for is 5,000, which I did. So now he's offering 500 in a deletion. So in response to that email, I was going to send back. I'm open to the settlement discussions. However, the terms proposed do not reflect the harm, the documented violations, or the time and resources already invested in pursuing this matter. For resolution, I would consider the following terms: full trade line deletion from all consumer reporting agencies, full debt forgiveness and closure of the alleged account, a settlement payment of $3,500 to me. Each party bears its own fees and costs. Upon receipt of written agreement reflecting these terms, I would be willing to discontinue the action with prejudice. Please provide the revised written settlement agreement for my review.
Let's
Damn right.
go.
nice.
Damn
Let's
right. Damn
go.
right.
I
Okay.
love it. Dude, 10 out of 10.
All right, perfect. So
Let's
Go.
go.
I'm gonna send that to him in the morning, and I'll let
Yep.
you guys know how that goes.
I can't wait to
Let's
read it.
go. I can't wait to hear about this tomorrow.
I got two more claims, one for a portfolio and one for Experian personal information.
Let's
So
go.
Can't wait to
yes,
catch
sir.
this lady
Yeah.
I
there.
appreciate the information
I'm
for
gonna
real.
punch
Good
them in the
job.
throat.
Good job.
Great
Nice.
job. Great
Thank you.
job.
Thank you.
All right, all right, all right. Let's go. Great job, Devin. All right. The credit's saying you're up, my guy. Talk to me.
What's up, bro? How you doing?
Man, we working, bro. What you got?
Well, I was looking at everything that you were doing, taking notes like always. I'm taking notes,
Mm-hmm.
and I'm doing things. I got some clients that's doing. I ain't got no lawsuits yet. I had one, but they didn't listen to me, and they lost everything.
All right, more
I got some,
opportunities will present itself. That's not the end of it.
yeah, but they didn't want to pay for it. They wanted me to do everything for a small fee and all
We're
that.
not, we're
Nah,
not, we're not, we're not doing that. A person unwilling to help themselves deserve to be left alone. That's just my
yeah,
opinion. If you're not going to help your own situation, bro, you're not my child. I am not obligated to you. And if you refuse to help yourself, hey, that's all I'm gonna say.
that's
I'm gonna
what
just say, hey.
that's where I'm at this point. But I got a few new clients. They're doing good. I did round ones on them.
Mm-hmm.
They just got what they got updated. But then they didn't do nothing. They didn't update nothing. They just said updated. So
Address
I
the
know.
update. Address that. There's a lawsuit. There's a lawsuit on CFPB versus Experian, CFPB versus Equifax. And in that lawsuit, there's a paragraph that spoke about deceptive responses. There is no clear indication of what an update means. What was updated? How was it updated? And what documents contributed to the update? We need that explained. So if they can explain that, hold on one second, guys.
Yeah, call this stuff.
We have to go. We have to go. All right. I'm gonna do a whole wrap up real quick, guys. I got a little family thing that I gotta handle real quick. All right. So credit saying, we're gonna wait on the next opportunity, right? We're not gonna push water uphill. We're not gonna try to save anybody that don't want to be saved. We're not out here in these streets being Captain Saver. All right. We're just not. If they don't want to be saved, don't save them. Leave them alone.
And I did send that email to you. I had talked to the people about it, but I wanted to get more input on it. But I did see the email and everything, how to do everything that I was talking about last time.
Which email address did you send it to?
The one you gave it to me on. When you gave it to me.
Contact or support?
Contact.
All right. All right. I'll get to it. I'm not gonna promise today or tomorrow, but I'm gonna get to it.
That's fine. I had talked to them about it when you had disappeared.
Okay.
I had talked to them that day. Yeah, I had talked to him and broke it down to him a little bit.
All right, no problem.
They got a little
Thank
bit.
you. All right, no problem. Thank you, bro.
Man. Yeah.
All right, awesome sauce. All right, Justin, talk to me, my guy. What's popping?
Hey, what's up, Durain?
Working, brother. Talk to me. What you got?
Yeah. Hey, so I got a I got a camera speeding ticket in the mail the other day. Someone told me, I heard along the way, that you can use consumer law to dispute this or delete it or make it go away or what's the story? What's the story?
With the cameras, it's a little tricky. I have done it in the past, but now they have updated the system. There was just too much information online, and they got smarter. So the camera ticket, you'd have to your grounds would be it would be calibration of the equipment. They have to provide that when the camera took the alleged picture, that it was calibrated and it was within compliance, so it accurately read the speed. And then we're going to talk about production of calibrated schedule. It's a whole thing. Like, to me, it was just not worth the hassle. If it's like a 25 or $50 ticket, I just don't want to deal with the hassle.
Yeah. Okay.
Mine was 158. I just paid it.
Yeah. There's
Based on
some
the
battles
picture.
like, you can win, but is it really worth the effort?
I thought I'd just do it just to do it. But
I mean,
yeah, you're right. I hear you.
You could carve out a brand new niche. You
Yeah.
could. Absolutely. I'm not saying don't do it. It's
That's
just for
true.
me, it's not worth it for me. I got
Yeah.
way too much stuff to be doing. I don't have the time.
Okay.
It can be done though. I've gotten toll tickets dismissed with consumer law.
Okay. Interesting.
Mm-hmm. All right, Super Dave, talk to me.
All right, how you doing, Ryan?
I am amazing, brother man. Talk to me. What you got?
Okay, I had a client. He he got a collection against Million Credit Management, and they said if they don't receive payment by 11/05/2025, they're gonna send it to an attorney. So I gave him a debt validation letter to send to them, and they haven't said anything back yet. So I want to know
Do you know that is a threat?
Mm-hmm.
Big threat.
Yeah.
That is a big threat. That's a threat
Yep.
of his character.
Okay.
Oh, that's a great lawsuit, brother.
Mm-hmm.
Dave, you in a connoisseur?
No, I'm not. I wish I was. No, I just joined this. I just joined
All right.
university.
So email finance. Let me give you this email address. Email finance. And let them work something out for you to join the connoisseur. Finance, FINANCE, finance at consumerlawsecrets.com. Email finance. and let finance know you want to join the connoisseur. Dude, that is a huge lawsuit. That is
Okay.
a threat to coerce payment.
Right. Yeah. Yeah. He showed it to me. Yeah.
And he got that in what? Writing?
It's an email.
Oh my God. It's even better. Oh yeah, join the connoisseur. We're gonna put this lawsuit together. You don't even need to respond to them. There's no
Yeah,
response needed.
I told him to respond to him. Yeah, don't respond to
You
him.
could, with a debt validation letter, that is the right response to it, a notice or validation of debt, per on the 12 CFR 1006.34C. That is an appropriate response. Nothing wrong with that.
Okay.
That just adds more because now if 30 days pass and they still can't validate it, you have a whole nother arsenal that you can now use in the asses, right? So you did not do anything wrong. Let's wait and let's see what happens. Did the letter got mailed out?
Yeah, he got mailed out, and we sent it with the certified mail, so we know he got it. They got it.
How long ago was that?
Let me see. How long did he say? Shit.
It doesn't matter. As
Okay.
long as it got sent out, it got delivered, and we started our 30-day clock. That's all I need to know.
Okay, yeah.
All right, let's get it, bro. That is great stuff, Dave.
Appreciate you, man.
Yeah, we finna get it.
All
right, no problem. Steve, you're up, my guy. Talk to me.
Hey, how's it going, Dorian? I was just
Man,
wondering, can we
working,
get
bro.
the
You know me, bro. I be working all the time. I be working and falling asleep sometimes. I be
yeah,
working so much.
now you doing your thing, big motivation and everything. You got me working. Yeah, I
What
was
you got
trying to
for me
see if we
tonight?
could get a copy of the notes right there. You know, the one you just had with the case laws and everything. Because I want to draft up a couple of the validation letters. You know, based on the case laws you sent and everything too, as well. Unless you already have some good validations, you know, I could start out with for a couple
Man,
collections.
y'all know Forbidden AI is packed. University is packed. But for those of you on here, 1 second. Yes. Open. The camera there. You come on. Hold on 1 second. 1,000. Oh, thank you very much, ma'am. All right. All right. Yeah, you know what? I'm gonna stop spoiling you guys though. You know that, right? I'm gonna stop spoiling y'all. I'm gonna drop it in the chat. And if you're not here on this call, you missed this document. So for those of you watching right now, you missed this document.
This big document. I'm
All
here.
right. Right, there you
Present.
go. So that's my teaching notes from tonight. All right. So there you go, Steve. I dropped it.
I got it. Saving it. D, you the man. You the man,
No
D.
problem. Y'all show up. Y'all show up. Y'all get some special treatment when y'all show up.
We show up and you show out.
No problem. All right. Thank you, Steve.
Thank you, D. Hey, you missed us the other day. We had it going, man. We had a
Yeah,
good
I heard
afternoon.
about it. I really appreciate you guys holding it out for me, man. We lost power, no internet. It was gone, bro. Whole blackout.
Damn, they still got that. I seen the weather thing out there. Y'all had like a hurricane or something, huh?
Bruh, it's crazy. It's crazy out here. It's still a wild, wild west, but we're making it work.
Yeah, no, for real. Real. Appreciate you, D. You know, you
Most
appreciate it on
definitely.
this side for sure.
I see all the love in the chat too. Well, you guys are most welcome. Yeah, I know I was gonna get all that thank you, and I appreciate that. Thank you. Makes it worth it. Sylvester, you're up. Talk to me.
Hey, how you doing?
I'm doing amazing. Talk to me. So what's going on?
Okay, so I had a motion to vacate a default judgment, and they granted it. Okay, so they sent me something in the mail. Opposition to defendant's motion to set aside judgment. That's what they sent in the mail. That's not them taking away the default judgment, is it?
Well, your default judgment got granted, right?
Yes.
All right. So what they're attempting to do is persuade the judge to set aside the default judgment in motion. Tell me
Okay.
the name of the title, what they sent you again. What's the name of it?
It says opposition to defendant's motion to set aside judgment.
Yeah, they're trying to tell the court that, hey, don't grant him a default judgment. Hear what we gotta say. Like that's what they're attempting to say.
Right, and they got
Man,
a statement of facts.
yeah,
Do
get out
you,
of here.
you think
My
that they will get this overturned?
Not necessarily. There's only the judge can do that. So if they have a strong enough argument that makes sense, the judge may consider it. But he already granted your stuff. So the fact that he granted your is like, damn, I made this decision, then I'm gonna go against my own decision. Like it's like you second guessing yourself. Do you really think a judge really wants to second guess him or herself? No. But if they present a strong argument and it makes sense, the judge could. But you got the approval already, so you got more than they do. So you now just have to wait and see what the response would be. This is kind of out of your hands right now until you get a response.
Okay. Oh, it's
I
okay.
don't think the judge is going to reverse the ruling though.
We don't have to say anything to this then.
No, it's just
Or
waiting
no
right
reply.
now.
Okay. So
you could though, you could answer respond to plaintiff's request to set aside default motion, and you basically just drag them through the mud. Plaintiff has been a deceptive, like you would just create a whole narrative now that they're, even though they lost and they don't have a case and they violated the law, they're still undermining the judge's decision, basically putting a motion that the judge made the incorrect. Like there's ways you could sway the argument, right? To let them be the bad guy, but that's if you want to.
Hey, what was the name of those attorneys that you guys had at the credit summit?
The ones I had was from Legal Shield, but I've
There
been
it
hearing a
is.
lot of complaints about Legal Shield, bro. It's not a recommendation I want to do anymore.
Oh, damn.
Yeah, I've been getting a lot of complaints, man.
NACA. Go to this site called NACA. NACA.
Drop the link, Mikey. Just drop a link.
NACA. NACA attorneys. You don't gotta pay them no money.
Gotcha.
Yep.
Hey,
Drop the
Durain,
link.
do I need to pay to get the AI? Because I've been trying to sign in there and I can't get in there for some
Which
reason.
one, the AI? The software?
Yes, your software.
We've been having some issues with the software and the developers that's been working on the software. I'm not getting a hold of them. So the software may be down for a little bit longer. I honestly don't know what coding error happened, and I'm unable to get a hold of the developers. So it's still a work in progress. We definitely will be sending out an email very soon, though. All right.
Okay, that's fine. I appreciate it.
No problem, my guy. Thank you very much.
Thank you.
All right, Ivy, you're gonna be my last question. All right, talk to me, Queen. What you got?
Your how to punch the credit. What does that mean? Unclean hands.
Unclean hands is when they are operating like they're
deceptive.
They're operating like they're in good faith, but they're operating with dirty hands behind the scenes
and violating the law.
So tell you what, I'm gonna use tomorrow's first part of the connoisseur to break down unclean hands. How does that sound?
Good.
All right, I'll break that down for you the first
last
10 to 15 minutes of class tomorrow.
Last question quickly. I've been upgrade. They charged me off. They sold it to Velocity. And my 3 letters of validation, no answer from Velocity.
Has it been more than 30 days?
The first one, yes. The second one, no, not yet. But
so I would use when a furnisher does not respond in 30 days or a creditor does not respond in 30 days. I would use that.
Okay. No response. But they're not reporting. It's Upgrade that's reporting.
And Upgrade, do you have documentation where Upgrade say they sold it?
Yes, it's in the credit file that it says it's sold.
Okay, so then now I would dispute that debt again. Dispute that account again under inaccurate information being furnished, incorrect creditor being reported.
Okay. All right. Thanks.
Creditor lacks ownership
Okay.
of alleged account.
Lacks ownership. Okay. Thank you.
Yep, no problem.
Hey, Durain, before you go, what's that law that you was telling me, the case law about the CLPB versus about
Oh,
updating?
CFPB versus Equifax, CFPB versus Experian.
Okay, thank you.
Yep, no problem. All right, guys, have a great night. Sure, students, I will see y'all tomorrow. We're gonna go over the highlighted section in the document, and we're gonna go over unclean hands. What does that mean, and how do we use that to protect ourselves against debt collectors and or furnishers? All right, so we'll talk about that in tomorrow's class. Everyone, have an amazing night. Peace. Your boy is out.
Thank
Thank
Bye,
you.
Durain.
you.
Thank you, Rain.